This is the Joy of Resistance, Multicultural Feminist Radio. And do we have our guest, Wendy Murphy, on the phone? Wendy, are you there?
I'm here, Fran. Thanks so much for having me.
That's great. It's wonderful that you're there. And speak up just a little bit. I am thrilled that you are here. Absolutely thrilled. Let me tell our audience a little about you. Wendy Murphy teaches sexual violence and law reform at New England Law Boston, where she also co-directs the Women and Children's Advocacy Project, or WCAP. Her litigation in the area of campus sexual assault beginning in the early 1990s includes groundbreaking victories against Harvard College in 2002, Harvard Law School, and Princeton University in 2010. And these cases led to widespread awareness and reforms and produced the well-known April 2011 Dear Colleague letter from the Obama administration. And my comment that made the playing field, let's say, more equal for women who experience sexual assault at college, on college campuses, which has been rife. In January 7th, 2020, WCAP filed a federal lawsuit in the U.S. District Court for the District of Massachusetts to ensure validations of the Equal Rights Amendment, or ERA, in the aftermath of ratification by Virginia as the 38th and last state needed to add the ERA as the 28th Amendment to the United States Constitution. Wendy is an impact litigator whose work in state and federal courts has changed the law to better protect the constitutional and civil rights of abused women and children. She has worked for NBC, CBS, CNN, and Fox News, and regularly provides legal analysis for network and cable news programs. Okay. And let me say to our audience, that is a very abbreviated version of her resume, which is humongous and would take up half of our show. Once again, welcome, Wendy, to Joy of Resistance. Good to have you back.
Thanks so much. Glad to be here. Thank you.
Okay. So we usually start, when you and I speak, we usually start by telling one of your stories about how you were winning cases regarding women's rights, but judges were kind of telling you or implying that they couldn't enforce your wins because there was no really legal grounding in the United States, in U.S. law, really, for them to enforce your wins. And that is, of course, because women are not in the United States Constitution. So have I got that part of it right?
Yes, it's very simple and complicated. So let me try to boil it down. In short, having been a litigator for coming up on 40 years now, it amazed me, but it also taught me a lot that I would stand up in front of a judge in whatever kind of case it was, sexual assault, sex discrimination, harassment, on any kind of discrimination against a woman, where I would see the court treating a woman differently and worse because she was a woman. I would object, and the courts would say, your objection is fair. I am treating her differently and worse. But it's allowed because women do not yet have equal rights under the Constitution in this country. When that became clear to me, I kind of shifted my work as an attorney to not just going into court and arguing for the individual rights of my specific client, but using the cases that I was handling for individuals as test cases to force them into the appellate court context where I could then argue for systemic reform. And I've been doing that ever since, pretty consistently saying to appellate courts, do you see how women are being treated unequally? This is because the Constitution is defective. It does not equally protect women. It does not require equal enforcement of any laws when applied to women. Please help me fix that. At a minimum, I was calling attention to the problem. Invariably, I wouldn't win. No judge felt, let's just say, compelled by my moral and, I don't know, humane.
Excellent arguments.
Well, just, the nature of a democracy, you're saying, how dare you treat women unequally? Very few judges would be interested in engaging in the debate because it's kind of a dirty secret in this country. Very few people, including academics, law professors, and certainly most women, are even aware that women do not yet have full equal citizenship, full equal rights, meaning a right to equal treatment under all laws, equal enforcement of all laws. As
Right.
Justice Scalia said in 2011, it's not that the Constitution requires discrimination against women, it's that it doesn't prohibit it. And he was right then, and he's still right today.
Yeah, we've had Jill Hasday who's written a book called We the Men, which is an obvious play on the phrase "we the people" that begins the Constitution, and and she traces that. Yeah. Okay. So this is, I assume, why you have been laser focused on getting an ERA for quite a long time and for a number of suits about it. And the ERA, we won't go into its whole history, but because that would take a very long time. But it is stalled. It's gotten the 38 ratifications that is necessary as the end of the long ratification process, and yet it is not being upheld by the courts. An artificial time limit was placed on it in the 70s, and it couldn't possibly have met it, but it's not essential to it. Nevertheless, that is the excuse at the moment. So if you want to add anything to that, please do. And then we'll get to what you are doing at present
Yes.
with your
Well,
newest
I
suit.
think I can give a pretty quick history.
Go ahead.
Women, when this country first began, women weren't even persons. And then when the Constitution was adopted, and pretty soon thereafter, the Bill of Rights was added, and then we had the Civil War, and we added the most important amendment in the eyes of many, which is the 14th Amendment. That amendment said all persons, that was the word, persons, shall have equal protection of the laws. Well, women initially were delighted because they thought they were persons, but the Supreme Court consistently refused to recognize them as persons and did not, in fact, recognize them as persons under the 14th Amendment until 1971. The 14th Amendment was adopted in 1868. We didn't become persons until 1971, which is one of the reasons so many things changed in the early 70s. Women could get credit cards in their own names. They could sit on federal juries, et cetera. If you're not a person, you can't even assert those basic rights. Well, becoming a person changed things for women, but when the Supreme Court said women were persons under the 14th Amendment in 1971, they said women's equal protection rights would be unequally enforced. And that was a very serious problem for women because it looked like we were now persons with equal protection rights, but the way the court worded the ruling was to give us unequally enforceable equal rights. Now, just getting your head around that is so hard.
Yeah. What a
It
phrase.
became, it became
Unequally
very
enforceable equal rights.
exactly. So most
My
people,
goodness. Yeah.
because it's so
Go on.
complicated now, and the unequal rights that we used to see before 1971 were in black and white. Things that would say women cannot get credit cards except through their husbands. That was in black and white. Well, once the issue became unequal enforcement after 1971, it became harder to see because then it was the actions of the various branches of government, whether police, prosecutors, judges, all the government officials responsible for enforcing the laws could now enforce all laws across the board unequally, but it wasn't in black and white anymore. It was the systematic refusal, for example, to arrest men for rape or to actually enforce equal pay laws equally. Equal pay laws say women are entitled to equal pay, but because courts can enforce them unequally, they're actually unequal pay laws. But you have
Right.
to look harder to see the problem. That's why the ERA is so critically important. It would require not just equality in writing in the laws, the way the text is worded, but in the enforcement. All government officials, all branches would always be required to treat women equally with the ERA in place. And we desperately need it because at
Yeah.
this point in time, none of them have to treat women equally at all.
Yeah. And thank you, Wendy, for being able to explain that so well to our audience. You've certainly educated me about it. There's just so much to this. Let's get to your present case that you are filing and hearing that it will be coming up on December 16th. Should the government shutdown end by then? We're sort of counting on that, I guess. Um, could you describe the case you're bringing and what made you want to file it?
Sure. Well, I will take advantage of any opportunity to go to court and argue about women being unequal, because ultimately it is the courts, the judicial branch, that will determine whether women deserve equality. Some people like to go to Congress and ask for equality there, but it really doesn't matter what Congress does, because eventually the courts have to decide whether what Congress did was constitutional. So I like getting right to the point, filing lawsuits, complaining about the constitutional deficits, asking courts to fix the 14th Amendment. We've waited long enough. It's been way over 100 years. Get to it. Just give us our equality. So anytime I can file a case, I do, but I'm looking for the right kind of case. And that happened to me in the past year when I noticed that a case had been filed in California federal court by a man suing the government for discrimination against men and women, because only men must register for the draft, and women not only need not, but cannot register for the draft. This has been a contentious area for many, many years. Why do men have to register for the draft, but women not only need not, but cannot? Well, that's because there's a federal law on point that mandates men starting at age 18 register for the draft and forbids women to do the same. The lawsuit that was filed in California was filed by a man on behalf of a men's rights organization who said, the time has come, let's put women in the draft, let's make women register for the draft. However, let's maintain their status as second-class citizens. Now, this is the thing that bothered me so much that I felt compelled to file my own lawsuit under the same rules, but on behalf of women, and a demand for fully equal treatment of the Constitution, in addition to let's fix this gender discriminatory law. And I did that because this man, his name is Vikram Valame, he said this law discriminates against men and women and is now illegal because of the Equal Rights Amendment. Now, you'd think that was a good thing, because
because he's saying it's already valid.
Exactly. So he sounded like he was a supporter of the ERA. And I said, this is wonderful. Where'd this guy come from? I didn't see him supporting the ERA in the past 10, 20 years. Where did he come from? Well, he was, in fact, just taking advantage of the point that Biden, on his last day in office, wrote a letter of no legal real value, but he wrote a letter to the public saying, I believe the ERA is valid. So he says in his lawsuit, the president has declared the ERA valid. 38 states have ratified the ERA, so women must now register for the draft. Again, sounds good, looks good, especially to have a man arguing for women's rights, except the one thing women get from the ERA is a mandate that the courts apply the strictest legal scrutiny when addressing women's claims of discrimination. This man was saying the ERA is valid, but don't apply the strictest scrutiny. Keep them at that lower second-class status of middle scrutiny, intermediate scrutiny. So in a sense, he's saying, yes, the ERA is valid, but I would like the court to rule that it has no impact whatsoever on women's equality, because I want them to still have that lower intermediate scrutiny rather than the full equality scrutiny, which is known as strict scrutiny. I was so irritated to see him asking for women to bleed to death on the front lines of battle as second-class citizens under the ERA that I ran into court with my own case. And I told the judge in my first pleading when I filed my lawsuit, I said, I'm filing this because that man's case could well land before the Supreme Court, and I'll be damned if, as a woman, a man advocating for men's rights gets to take the ERA to the United States Supreme Court and ask them to read it and interpret it as if it gives women second-class rights rather than full equality. So in my lawsuit, I shame him for how he filed his lawsuit, and I demand from my judge that if the ERA is valid, I want full equality under the strictest standard of judicial scrutiny.
Let me interrupt for a minute. Please explain the concept of strict scrutiny and why it is so important.
Yes, absolutely. It can be complicated, but I describe it as simply as I can, like this. If strict scrutiny applies when the courts are reviewing your claims of discrimination, it means almost no discrimination is tolerated by the courts. Strict scrutiny means you have to have, and again, this applies to the government. So if the government discriminates against you and the courts apply strict scrutiny, they have to overturn the government's rules or policies unless they have a very compelling reason for discriminating and they've used the least imposing means to do it. In other words, they've written the law as tightly as they could to make sure that no needless discrimination is happening. That's what's
and there are different levels of scrutiny for all of these kinds of cases. And could you describe what they are?
That's right. So strict scrutiny means very little discrimination is tolerated by the courts. Women are way below strict scrutiny right now. We are at intermediate or middle tier scrutiny, which is a vastly different standard. And it means that if a woman goes to court to say, I've suffered discrimination, the government is treating me differently and worse because I'm a woman, the court is allowed to endorse the government's discrimination against women, even if there's no compelling reason for the discrimination, and even if the law or the rule could be rewritten to be less harmful to women.
Yeah. So strict scrutiny is the prize, and it comes with having an ERA, which is one of the reasons the ERA is so necessary. Is that correct?
That's a good way to put it. Strict scrutiny is the prize, but the even simpler way to put it is this: strict scrutiny is full equality. Intermediate scrutiny is second-class citizenship because it allows much more discrimination to happen by the government than is tolerated under strict scrutiny. I mean, if you could put it in numerical terms, 10% of discrimination is tolerated under strict scrutiny, 30% of discrimination is tolerated under intermediate scrutiny. Women just want to be at the top tier, equal with all other categories of people, instead of in this space where, because of intermediate scrutiny, we have police and prosecutors disproportionately refusing to file charges or prosecute cases when men abuse, beat, and kill women. You know, we have, as I said, unequal enforcement of equal pay laws. We have, frankly, the disrespect for abortion rights. That comes from a systematic, constitutionally tolerated space for discrimination against women.
Okay, I'm really glad you explained that. I hope our listeners were catching up with it. We're keeping up with it because it's a very legalistic term. But the way you explain it, I think, for me anyway, makes it very clear, because what you're saying is that is part of the point, if not the largest point, of getting an equal rights amendment. It would give us strict scrutiny.
It's the only thing we get, Fran. The only thing we get from the ERA is a bump up from lower intermediate scrutiny up to strict scrutiny.
Okay, good. I'm glad you made it that simple, and that's why it's so important. But apparently, and the ERA is stalled right now. We don't know when it will be unstalled. Apparently, there are other ways of getting to strict scrutiny, and that is also what you are asking for in your current suit. Right?
That's
so
right.
Try to tie that in, the strict scrutiny, the 14th Amendment, and your current suit, and how that relates to this issue of women having to register for the draft as do men, and even tell me why that would be of advantage to women.
Yeah, sure. So first and foremost, my case makes two claims. It makes the claim that the law that requires men but forbids women to register for the draft is discriminatory and unconstitutional under the ERA. And because the ERA is valid, that is to say, the right number of states have ratified it, it is now part of our Constitution, you, judge, should recognize it, and you should apply strict scrutiny because it's valid. And under strict scrutiny, that law is unconstitutional. You need to overturn it. That's my first argument. That is a way to give us strict scrutiny by having my judge declare the ERA valid. It's a good way to get us up to strict scrutiny through the ERA being validated by the courts. My
Mm.
alternative argument is if you think the ERA is not valid because it was not ratified by the requisite number of states in the time period allotted, which is to say there's a time restriction on when the ERA should have been ratified by the states that expired many years ago. We make the argument that the time limit is invalid, so it doesn't count. But if this judge thinks the time limit does count and the ERA expired, I've given him an alternative, which is to say just rule that under the 14th Amendment, forget the ERA, under the 14th Amendment and the analogous Fifth Amendment, which is the same as the 14th for our purposes of equal protection, they both have equal protection provisions, just rule that under the 14th Amendment and the Fifth Amendment, women are now entitled to strict scrutiny. Now, why would I be
Mhm.
allowed to ask for that? Because it was the courts that initially said women only get lower tier scrutiny. That didn't come from Congress. That didn't come from the ERA. That didn't come from any constitutional amendment. It came from the courts saying there's an equal protection guarantee in the Constitution. We're going to give it to women, but we're going to enforce it in a very low level where it's
Okay,
not
so
actually
if your suit succeeds, we should get either the ERA validated with its strict scrutiny provision or
yep,
strict scrutiny under the 14th Amendment. That is what you are going for, right, as the goal.
that's right.
Either of those.
What I said to the judge was, if women are going to die on the front lines of battle and bleed to death the same way men do for the first time in history by registering for the draft and fighting in combat and giving their lives. Women have always given their lives in the military, by the way, but if they're going to be mandated by the government to do exactly what men do in the military, you're damn going to give them equal rights before you change the law to require them to
That's
register
right.
for the
And
draft.
women are in combat and have been in combat, which Pete Hegseth, of course, is the head of the Department of War, is trying to stop because of his orthodox Christian nationalist beliefs about the place of women. Nevertheless, women have been active in so many wars in the past. But, there still is resistance, Wendy, to the idea of women registering for the draft, especially at a time when the military is being so misused, unconstitutionally being used, for instance, to attack citizens, which is not supposed to be the case under the posse comitatus law. So I think it might, it's a hard sell for some people. How do
Well,
you respond to that?
so I have two answers to that. One is, look, we're not in a position to say, let's not have a draft unless we have an equal voice in our country. So when I say to women, let's get rid of this discriminatory law that forbids you to sign up for the draft, I'm not just saying I like the draft, I like the military. That's not the issue at all. I'm saying, don't you want an equal voice in what the public is saying about the military? Well, unless you're one of the people who's registering for the draft, hence obligated to your country, equal to men in terms of what the military is, your voice is worth nothing. You can go out and protest, you're a woman, and people are going to dismiss you because they're going to say, which happens all the time, you don't even register for the draft. You are not in a position to complain about our military. As soon as you lay down your life equally to men, then we'll listen to what you have to say. I want women to have equal voices in all spheres of society. Well, that includes being a responsible citizen on par with men with regard to our obligations as citizens,
Yeah. And
including
and that was Wendy, that was also an argument made by many radical feminists during the Vietnam War. That we, in order to protest it, we needed to have that kind of standing of also being combatants. And we're back live. This is the Joy of Resistance, Multicultural Feminist Radio at WBAI, and we are speaking with Wendy Murphy, who is a very highly well known and esteemed lawyer who has a brand new case that is going for the ERA or its equivalent. That is going through the courts right now. I do understand that we have a few phone calls already, but before that, Wendy, very quickly, just tell us what the schedule is for this case so people can, kind of begin to understand how they can participate in it.
Sure, sure. So my case is in Massachusetts federal court. Its title is Equal Means Equal versus Donald Trump, because he's the head of the military. And it's easy enough to find if you go to the website of the Massachusetts federal court. And I encourage people who are interested in listening to how the oral argument goes, because we are facing a court hearing on whether the case should proceed or not. And that was originally scheduled for this month, but because of the shutdown, they've moved it to December 16th at 2 o'clock. You can only listen by telephone if you register in advance. I think you can't register more than a day or two in advance, or you can go in person. It's right downtown in Boston, in the Seaport District. That's where the courthouse is. You can go in person. You can register to listen by phone. You cannot participate by Zoom. So if you're interested, please be there. The more the merrier. That's our feeling.
Okay, and we'll repeat that toward the end of the program. So we got a couple of calls on the line. Let's see who's out there. Caller, good morning. This is the Joy of Resistance.
Hello.
Hello, can you speak up, please?
Yes, hello.
Hi.
Hi.
A little louder.
I want to thank Wendy for her persistence, but I
Great,
do have a question about if the current mayor and if the progressive legislators decide that boys can be girls and men can be women, how that has an impact on the Equal Rights Amendment if boys can claim that they're girls and men can claim that they're women.
Very good question, a really good question, and a somewhat complicated answer, so I'm going to try to simplify it. The idea of people being able to declare themselves a different sex may or may not have an impact on the ERA itself. But what I want to assuage people in terms of people have concerns, like why bother to push for the ERA if at the end of the day we have these other laws that say men and women are the same and you can float into either category by declaration and just call yourself one or the other. What's the difference? Why do you need equal rights if you can just declare yourself a man, right? Well, the answer is protecting women against the harm that they might suffer if in fact a biological male, because that person identifies as female, can then either play sports against females or, enter in a nude state in a locker room, for example. If women have full equality under the ERA, it will be much harder for those kinds of laws to be enforced in a manner that imposes on the well-being of women. The way I like to describe it is that with women in second-class status right now, those laws are very easy to adopt and to impose by enforcement in a way that harms women. Women definitely benefit by the ERA because then they can make a stronger argument against those impositions because they are now fully equal persons with a right to strict scrutiny review by the government before those intrusions are allowed to cause harm to women. One of the reasons I feel confident that the harm question is going to be better for women under the ERA is because of the fact that the Supreme Court recently said there's a sex-based difference between males and females. So whatever you think about gender identity, that is never going to be sex. I say that because in the Scrutiny case from earlier this year, the Supreme Court was clear. Sex is binary. There's male and there's female. This is a biological reality. And the ERA is rooted in that biological understanding of the sex differences. This has no bearing on whether people who are transgender deserve respect and equal treatment. Of course they do. No one should suffer discrimination because of who they are. What we
Yeah.
have now is some confusion between what happens if you identify into the other category, but what we have, at least at this point, is pretty good clarity from the Supreme Court that sex is not the same as gender. End of discussion.
Okay. Listen, thank you for that answer and thank you for the question, caller. And we have some other calls. Let's go on to another call. Good morning. This is the Joy of Resistance, and you are on the air.
Hi, this is Steve, Beverly Hills. I enjoy this discussion very much. My mother is a member of NOW, now National Organization of Women. I don't know what it's morphed into.
By the way, that's National Organization for Women. Everyone makes that
Yeah,
mistake.
for women.
But please go on.
She's seen a lot. Anyway, I was going to ask you if you can decentralize the presentation for a moment and look at Europe. Have you formed a kinship with women in Europe who are going through many situations, especially with migrants? Because the migrants are being counted like they are in the United States, New York City too, as tourists. So they're not counting the tourist crime caused by migrants, which is this, that, and the other thing, as you might imagine. So also, in the United Nations, have you formed an NGO for everyone? Because this is an important thing. We can't have tourism in Europe anymore. We have advisories and warnings.
Excuse me, caller. I'm sorry, but as far as I am concerned, you are way off the topic. You are getting into some you are getting into some very disputed areas of great concern to a lot of people, and we are running out of time. I'm going to ask you if you can keep your remarks to the ERA and women's rights as we are discussing.
Oh, I think it's very complicated with the Supreme Court. They've become the kings of the world. But thank you very much. Bye-bye.
Bye-bye.
I can say one quick thing, Fran.
Go ahead.
Because it has always mattered that women in America unite with women, especially in Western Europe, when fighting for their rights. It was very important when we were fighting for the vote that we had the allies in England and in some of the Western countries. So I do work with women in other countries, and they are experiencing very similar problems. But the other thing that's important is the UN, and they've done this year after year. The UN does research and produces papers pretty consistently and has said over and over again that no country on earth has actually established equality for women, even countries where it looks like women have equality in the constitutional language. It's the enforcement that's the problem.
We just had a story about Sweden where women are being charged. If they mention the names of abusers, they're being charged with libel. We've just got one more caller coming in. I wonder if we can get in a quick caller. Caller, we're going to ask you to be very concise, but you are on the air on Joy of Resistance. We'd love to hear from you.
Hi there. Hi, can you hear me?
Yes.
I would like to join the conversation midway. The term strict scrutiny, could you go over that with us, please? The term strict scrutiny, was it?
Sure. Give him the quick answer, Wendy.
Yep.
The quickest answer.
Strict scrutiny is the standard courts apply when addressing women's concerns about unequal treatment. Strict scrutiny, I should say, let me clarify. Strict scrutiny is not the standard courts apply when addressing women's concerns about unfair treatment. They apply a lesser standard called intermediate scrutiny. The difference is really important, and it's the reason we're fighting for the ERA. The ERA would require them to apply strict scrutiny. Under strict scrutiny, the courts have to strike down the unfair treatment of women unless there's a justification that's compelling, and it's the only way to, carry through whatever it is the government's trying to do. In other words, you can have discrimination in the law, even under strict scrutiny, but you better have a damn good reason, and it better be written as tightly as possible. Under intermediate scrutiny, which is what applies to women, you don't need a good reason. You can have virtually any reason at all, and you don't have to write the law in a tight way that
Yeah.
that protects against needless discrimination. You can basically discriminate against women willy-nilly under intermediate scrutiny.
Right. In other words, I'm cutting you up a little bit, Wendy, because of time. We have to end the show very shortly. So basically, it's the highest level of government involvement in your equality. If you get that
it's
level,
the highest level of protection. The
highest level of protection. Okay, caller. Glad you asked that question, because it's legalese. People sometimes, don't want to deal with it, but it's not that hard. Anyway, Wendy, I've enjoyed having you on so much. Before you go, please let's repeat how people can get in touch to actually sit in on the hearing on their phone, which is scheduled for December 16th. And I don't know if we've mentioned it, but the Supreme Court has expressed interest in this case, as well as the Val May case.
Yes.
And that's one of the reasons this is so important. So anyway, tell us how to do that, how to get to hear this.
Yes, there are 3 cases pending, one in New Jersey federal court, my case, and then the Val May case in California. They're all raising the same question about women registering for the draft, and the Supreme Court in 2021 said it is interested in resolving this issue once and for all. That's one of the reasons I filed my case.
All right. We are just, Wendy, we're just really closing down because we're supposed to be off the air at the 55-minute. We want to go out with our theme song, with another song. So let's just maybe ask our audience to go to equalmeansequal.org for more details on how you can get to hear this hearing and also the progression of this case, in relation to the shutdown and everything, because it is a very important case. Yes. Wendy, I want to thank you so much for coming on and explaining in the wonderful way that you do this very complicated case that could have a really important effect on women's rights. We've even said it could revolutionize women's rights if you get what you're asking for, which is strict scrutiny or validation of the ERA. So let's leave it there. And thanks so much for being a guest.